Webinar is by Miller Thompson. Miller Thompson is one of Canada's most respected law firms with over 550 professionals practicing in 12 offices across the country, including Toronto, Markham, Vaughan, Kitchener-Waterloo, Guelph, London, Vancouver, Calgary, Edmonton, Saskatoon, Regina, and Montreal. They go beyond a strict technical analysis of the law. In providing advice, they take a practical approach that combines legal knowledge and analysis with risk management, quality improvement, cultural, structural, and resource considerations. Their team-based practice ensures that issues are addressed at the appropriate stage and form part of their risk-managed approach to legal services. Miller Thompson's health industry practice is one of the firm's key industry-focused teams. They have a consistent track record in providing practical, creative, and cost-effective advice, combined with an unyielding service commitment to their clients and the communities in which they practice. Our speaker tonight is Meg Berkowitz. Meg is a lawyer at Miller Thompson LLP, practicing exclusively within the health industry. Meg's practice focuses on providing advice to private and public health and social service organizations and industry associations. Meg assists clients with contract matters, corporate structuring, procurement, mergers and program transfers, intellectual property, and other general commercial matters. Welcome, Meg.
Thank you so much, Cheryl, and thank you all for having me speak with you this evening. There are quite a few of us on the line, and hopefully we'll have a nice discussion at the end of the session. So I won't hold this up any longer, and we can get right into the session. So I'm going to be asking Kim to advance the slides for me this evening. So Kim, if we can go to the next slide, we can go right into our first poll question. And our first poll question that we'd like to have you answer is whether you currently have a lease for your optometric clinic space. This can be any type of lease, whether you're renting a whole building, you're renting space in a unit, or a unit inside a building, like a mall, for example. I'll give you a few seconds to enter your answers, and then we'll view the poll results. So we're about even, it looks like, on the results, about 50, actually right on. We're 50-50. Some of you currently lease and some of you don't. So for those of you that don't, we'll go to our second poll question, which is, if you don't currently rent any clinic space, do you intend to enter into a lease for clinic space in the future? And this doesn't have to be the immediate future. Even if it's just something you're pondering, just let us know whether you think it's a possibility. I'll give you a few more seconds to answer, and then we'll view the results together. Okay, so that's great. So 92% of you who don't currently have a lease said that you may, in the future, consider entering into a lease arrangement for some clinic space. So that's really great, and thank you for taking the time to answer those poll questions. So regardless of what you answered, and Kim, we can go to the next slide now. Regardless of what you answered or which bucket you're in, what we cover today will hopefully be useful to you in one way or another. And we're going to start our session today by covering the key components that you're likely to find in every commercial lease. We'll then take a brief look at the regulatory requirements around access to space. We'll also take a look at some things that we have to consider in this new reality of COVID-19 as it relates to space, and some government supports that might be available to you as tenants. And we'll finish off with a quick summary of the session. Next slide, please. So before we dive into the key components of a lease, it's important to understand what a lease actually means. So first and foremost, a lease is a contract, and it's created it creates a property interest in certain space, and it includes the right for the tenant to possess that particular space. Under a lease, the relationship of landlord and tenant is created at law. And so when that relationship is created, in most instances, the Commercial Tenancies Act of Ontario will apply. There are other types of space arrangements that can exist. It's not always a lease arrangement. So there are instances where you could have licenses for space, which are different, where the parties, or at least one of the parties for whatever reason, doesn't want to be subject to the commercial tenancies legislation, and so parties may opt to enter into a space license agreement instead. Today we're going to specifically talk about lease arrangements, as those are the types of arrangements that appear to be the most common for optometry clinic spaces. And what's also important to remember is that there is no one-size-fits-all when it comes to leases. And like many other types of contracts, the type of lease and the provisions in that lease will greatly depend on the industry that you're in, on the type of business being conducted, and even the location of the space itself. Next slide. So let's take a look at some of the key provisions that you're likely to find in almost every commercial lease for clinic space. I've listed them all on the screen here, and we'll take a look in more detail at all of these provisions as we go through our session together today. Next slide, please. So the first and one of the key items to address, as obvious as it may seem, is what is actually being leased. Is it a whole building, which could be the case more often in areas outside of a major metropolis? Is it a unit in a building, like, for example, a storefront? Or is it clinical office space inside of a unit? The type of space that you are renting may impact the type of lease agreement that the landlord will ask you to sign, and how extensive that lease agreement will be. There are some, what I'll call quote-unquote standard form leases out there, for example, from the Ontario Real Estate Association, that some landlords may choose to use when they're leasing out space. But regardless of what form or type of lease that you're entering into, it's important to have clarity as to what is actually being rented. So you should ensure that the description of the space is clearly set out in the lease contract. And this would include, for example, the municipal address, which is the most common type of descriptor, the unit number, if there is one, the square footage of the space as well. And this is especially important if the rent that you're paying under the lease is tied to the square footage of the space. And if you're leasing space that's in the same building as other businesses, which will be the most common type of lease, then it's also important to include in the lease agreement the right to use the common areas of the building. And so what do we mean by common areas? This includes communal washroom facilities, for example, hallways, sidewalks, parking areas, and some other general common areas that would typically be used when you're sharing a building with other tenants. And the right to use the common areas is most often non-exclusive right, meaning that you and your clients and staff will be allowed to use it along with others in the building. It's not exclusive to you and your clients and staff. And the common areas, as we'll talk about a little bit later, are typically the responsibility of the landlord in terms of both maintenance and repair. Next slide, please. Another key provision that's typically included in lease agreements is the permitted use clause, meaning what can you actually use the space for? So in this instance, it would be important to specify that you're permitted to use the space for the purpose of an optometry clinic and also any other ancillary or related uses. So for example, dispensing and sale of contact lenses and eyeglasses and accessories and things like that. So when thinking about the permitted use clause in a lease as a tenant, it's always better to think a little more broadly rather than narrowly when describing the use. but of course it should still be appropriate to the circumstances. For example, if you're entering into a lease, your landlord is unlikely to allow the space to be used for both an optometry clinic and a fast food restaurant or a bingo hall. And yes, I realize these examples might be of a stretch, but hopefully they just illustrate what we're trying to get at here. For a landlord of a retail commercial property, it might be important to achieve a good tenant mix. And so the permitted use provisions are an important means for the landlord to control the mix of tenants on the property. For you as a tenant, on the other hand, you'd also want to build in some flexibility. And this could especially become important in the event that the lease is transferred or assigned to another party in the future. So as to maximize the type of entities and other organizations to whom the lease can be transferred by you as tenant. So while you may specify the permitted use as an optometry clinic, you could also attempt to negotiate, clinical, office space, and ancillary uses to provide some greater flexibility in the event that later on you do end up assigning the lease and the space to a third party. Then it doesn't just have to be an optometrist, it can be some other clinical or medical space. And from the tenant's perspective, it's important that the lease include also provisions allowing access to the space in the common areas after, your quote-unquote business hours or normal operating hours. This is especially important given the regulatory requirements around access to the premises, which we'll touch upon a little bit later in our discussion. Next slide. So another term that might be obvious to include, but is important not to gloss over, is the term of the agreement. What is the length of the lease that you are entering into? Is it a short-term lease, which we typically see as being between 1 and 5 years, or is it a longer-term lease, which is typically anywhere from 5 years and up? The length, or as we like to call it, the term of a lease, could be impacted by the type of premises that are being leased. So for example, if you're leasing a whole building, it's likely that this would be a much longer term lease than if you were leasing an office space or a unit within a building. There's also no requirement for a lease to start on the first of the month. Landlords may prefer to have the same start date for leases if they handle multiple properties, just to simplify their own accounting with rent payments, but there's really no legal right or wrong around the date on which a lease can start. It's whatever the parties end up agreeing on. There are also renewal or renegotiation rights that might be built into a lease. While this can really be done without written agreement, it might be beneficial to have these rights built in so as to provide assurance to you as the tenant that the landlord will be required to renew the lease if certain conditions are met. So for example, rent. Another concept that I'm going to touch on is the concept of holding over, which can be found in most commercial leases. And holding over is when a tenant remains in possession of the premises or stays in the space at the end of the term of the lease. An overholding clause does not provide you permission to stay beyond the end of a lease. So it's not as if suddenly you're allowed to stay just because you have an overholding provision. What it does is it sets out the parameters for overholding in the event that the tenant doesn't vacate the premises on time for whatever reason that may be. And so under the Commercial Tenancies Act, in the event that a tenant does hold over, the Commercial Tenancies Act actually states that the rent shall be 200% of the rate that's set out in the lease. So double the rate that's in your lease if you hold over. But in many overholding clauses in lease agreements, the landlord and tenant will usually agree to a lesser rate, and we typically see between 125 to 150% of the rate that is set out in the lease. There could be benefits to both the landlord and the tenant from an overholding perspective. So for example, a landlord can benefit from a tenant overholding by obviously collecting a higher rent than ordinary, especially if the space might otherwise sit empty. And on the flip side, a tenant can benefit from overholding if it needs to remain in the space as a stopgap measure. So for example, if you've arranged for a new clinic space and to move into that space and it's not ready yet, you have nowhere else to go, or a renovation of a new space goes awry, you might try to overhold your lease. These are not, things that happen too often, but they do happen, which is why we include these types of provisions in leases for the benefit of the tenant. Now, just because you have an overholding clause in your contract doesn't mean that the landlord has actually consented through that clause for you to stay and overhold. If the landlord does not agree to the overholding, you can't remain in the space. But if the landlord does accept overholding rent from you as the tenant, they're legally deemed to have consented to the overholding, and then the terms of the lease around the overholding would apply. So that's why we do include them in the lease. And a lot of leases state that overholding will be considered month to month with a 30 days notice to terminate from either party. So it essentially becomes a month to month tenancy at that point. Next slide, please. One of the provisions, of course, that people pay the most attention to is, not surprisingly, the rent. The rent to be paid under a lease will depend on the type of lease that it is, and there are two types of leases that we'll talk about. There's net lease and there are gross leases. So net leases are those leases that break the rent down into what's called a base or minimum rent and additional rent. And additional rent covers things like operating expenses and includes things like maintenance, utilities, municipal taxes, and they're typically calculated on a proportional basis based on the square footage that you occupy as a tenant in the building. Gross leases are what we call, quote unquote, the all-inclusive leases. So it's a fixed monthly amount, which means that the landlord is absorbing the part that would typically be considered the additional rent. Of course, this does not mean that the landlord is providing the equivalent of the additional rent for free. It just means that that's probably just built in to your fixed monthly payment. So why the difference? Why do we have two different types of leases? So net leases are typically used for longer term lease arrangements, given the fluctuations that may occur with items that would typically fall into the additional rent category, like utilities and taxes. And they are more complex. They're much more complex leases, so they may not be suitable for low value or short-term arrangements. The rent can be stated as annual rent to be paid monthly or simply as monthly rent. Again, there's no legal right or wrong. And of course, leases will also specify when the rent is to be paid. Longer-term leases also tend to have a rent escalation built in, which is typically calculated based on the square footage of the space. So, for example, in years 1 and 2, you'll pay $20 a square foot. In years 3 to 5, you might pay $25 a square foot, and then in years 5 to 10 of the lease, it might go up to $30 a square foot, something like that. There's also instances, as I'm sure you know of, where landlords provide administrative and/or management services to optometrists that rent space from them. And so in such instances, there might be a separate agreement in place to address those additional supports, or everything could just be addressed as part of one larger contract. It really depends on the type of space that's being rented and on your landlord. Next slide. Maintenance and repair. Who's responsible? So the landlord is typically responsible for maintenance and repair to the structural elements of the building. What does that mean? That means the roof, the heating and ventilation system, the foundation, the exterior walls, things like that. The landlord is also responsible for maintenance of the common areas, so common hallways, parking lots, driveways, loading areas, sidewalk, any landscaped areas around the building. The tenant may be responsible to maintain the non-structural elements of the space. For example, any interior partitions, maybe the floors and the lighting in the unit. But this will, of course, again, depend on the type of lease that you're entering into and what kind of space you're leasing. So, for example, if you're leasing a clinical office space within a larger unit, it might actually be that the landlord would be responsible for all those things under the lease, but those things can and often are negotiated. The important thing to remember is that the lease should be clear on who's responsible for what, and also importantly, who pays in case something needs to get repaired or replaced. Next slide, please. So flowing from maintenance and repair are alterations and improvements. So another question to ask is, does the lease permit you to make any alterations or improvements to the space to suit the functioning of your clinic? Hopefully the answer is yes. Do you have permission under the lease to put up signs on the exterior of the building or the exterior of the unit? If the lease is for a space that's within, a medical office building, for example, is the landlord obligated to list your business in the building directory? All things that would typically be covered under the lease. Typically, the tenant won't be permitted to make any alterations that would affect the building structure, but other alterations are quite common, especially if you're not getting a turnkey space. So to ensure that it can function the way that you need it to function when running your optometry practice, so for example, the division of the space into a waiting area, an exam room, an admin area for staff, and then putting in your equipment, your shelving, your counters, etc. The lease should also stipulate what will happen to the fixtures and any improvements that you put in while you're occupying the space at the end of the lease. Do you get to take it all with you and have to restore the premises to their original condition? Does the landlord get to keep everything? What happens at the end of the lease if you haven't removed all of your equipment or inventory from the premises? Does it become the property of the landlord, or do you have the right to go in and remove these things? We often include these types of provisions in leases for clinical space, since as a tenant, you wouldn't want to forfeit those items as they're very significant business investment. So these are all things that you should consider and that we would pay attention to when we enter into leases as tenants. Next slide, please. You'd be very hard-pressed to find a lease agreement that did not address insurance obligations. Insurance is typically broken down into what the landlord's required to insure and what the tenant is required to insure, which can be similar or different, again, depending on the type of space that's being leased. So most commonly, the landlord would be required to carry building insurance, insurance for any equipment that belongs to the landlord, insurance to cover machinery and boilers, insurance from perils like fire, and general liability for insurance or property damage that might occur on the areas that the landlord is responsible for. So, for example, common areas. The tenant's insurance, the insurance that the tenant would be obligated typically to carry is comprehensive general liability insurance for property damage and personal injury that would occur in the space that's being leased, as well as insurance to cover any improvements, equipment, furnishings, and fixtures that are installed by the tenant. So what we do strongly recommend is that before signing a lease, you review the insurance obligations under that lease together with your insurance provider to ensure that the insurance that's being requested of you is appropriate in the circumstances and that you actually carry the insurance that is required when you enter into the lease and before you become an occupant of the space. Next slide, please. Indemnification and insurance provisions typically go hand in hand. They're two peas in a pod. So an indemnity is a contractual obligation to make another party financially whole for a third-party claim resulting from your acts or your omissions to act, from negligence, from breach of contract, or from any statutory violations. So an indemnity from a tenant would typically cover damages or losses that arise from claims by another party for an injury or property damage that arises from so the tenant's use and occupation of the leased space. And then sometimes it includes an exclusion in it, so unless the damage or loss was actually caused by the landlord. And then an indemnity from the landlord in favor of the tenant would typically cover damage or loss that arise from claims by another party for injury or property damage that arise in parts of the building that are the landlord's responsibility. So again, for example, the common areas, the hallway, and that are not the responsibility of the tenant. Landlords, of course, don't generally like to volunteer indemnities in their leases. So it is incumbent for us as your counsel and for you as the tenant to ask for them. Landlords may also limit their liability under the lease, sometimes to the fees paid under the lease, the rent, or another amount, like sometimes the available insurance proceeds. So it's important really to read these clauses all together, the limitations of liabilities, the indemnities, and the insurance, read them all together to truly get a sense of what the landlord would be responsible for in the event of a claim and what you as a tenant would be responsible for in the event of a claim. Next slide, please. So next we'll talk about assignment and subleasing. The assignment and subleasing sections of a lease provide the tenant with a certain amount of flexibility. It's also one of the main exit strategies that can be used by tenants. So the landlord and the tenant really have opposing interests in these types of clauses. The landlord, of course, as you would expect, would want to maintain as much control as possible of the party that's using and occupying their space. So while the tenant would typically want as much flexibility as possible to assign or sublease if that time ever comes. Regardless, it is very rare, if unheard of, that a tenant can assign their lease or sublease it to another party without the landlord's consent, and this is standard fare. The assignment provisions in a lease will also often state the tenant's responsible for the acts of the person that's taking on the lease from them, which may not be practical in the event that you sell your practice or need to assign the lease. So these provisions are normally negotiated by the tenant to ensure that they are reasonable if the time ever does come to assign or sublease the space. Next slide. So there are two different types of default that can trigger a right by the landlord to re-enter the premises. There's monetary default and a non-monetary default. So monetary defaults are for the non-payment of rent. They don't have notice requirements under the Commercial Tenancies Act. So under the Commercial Tenancies Act, unless the landlord and the tenant agree otherwise, the landlord has the legal right to re-enter and repossess the premises if the rent remains unpaid for a period of 15 days from the date that it was due, without any requirement to provide the tenant with any formal notice or demand. So it would be to a tenant's benefit to have the lease include provisions around notice of unpaid rent and an opportunity to cure that kind of default in payment. But again, that's not legally required. And landlords are often reluctant to grant a notice or cure period for rent default, but they're generally willing to grant longer notice and grace periods for non-monetary default. So if a tenant has a notice and cure period for a particular default, the tenant technically is not actually in default until the notice has been delivered and the cure period has passed. If you haven't cured it by the time that the notice period has passed, then you would be in default under the lease. For non-monetary defaults under the Commercial Tenancies Act, the landlords are required to provide reasonable notice and a cure period before they're entitled to exercise a right of re-entry or forfeiture. And there have been cases where a landlord didn't serve notice on a tenant in accordance with these requirements in the Act, and the landlord was held liable for trespassing and wrongful lease termination. So the provisions around non-monetary defaults in the Act are for the benefit of the tenant, and it's to allow an opportunity to remedy whatever breach it may be, and they can't be contracted out of. Next slide. So the last key lease provision that we'll just quickly touch base on is force majeure, events of force majeure. So many contracts, including leases, have a force majeure clause that sets out a list of the events and the parties' agreed upon response should any of these events occur. And the types of events can include acts of God, war, riots, and often actually also include in the list pandemics or epidemics. And so what do these force majeure clauses do? So they may delay the performance of obligations for a certain period of time following the occurrence of a particular event. They may excuse one or both parties from the performance of their obligations and maybe the resulting liability for non-performance. Or they could state that one party or another will still be required to perform their obligations or pay for non-performance despite the occurrence of an event of default, an event of force majeure. But events of force majeure may not, and typically do not, excuse a tenant from paying rent under a lease. So if the landlord has done their diligence and have drafted a lease contract to their benefit, they would typically exclude the payment of rent, even if a force majeure event occurs. So whether a force majeure can be relied on to relieve either a tenant or a landlord from performing their obligations under a lease is really a case-by-case analysis. And of course, it depends on the facts of the situation. Next slide, please. So now that we've covered some key provisions that can typically be found in commercial leases for clinic space, I'm going to shift gears a little bit and talk about the regulatory requirements that you should be mindful of when entering into lease agreements, as well as some considerations during this unfortunate time of COVID-19. And I'll start with the regulatory requirements and the College of Optometrists. So the College's independent contractor requirements and conflict of interest provisions under the Optometry Act state what should be included in an independent contractor agreement when an optometrist is engaged in the practice of the profession with anyone other than another optometrist or a physician. And they include access provisions that require an optometrist to be able to access the premises where you practice, so the space where you practice, anytime, day or night, at all hours. So keep these access provisions and requirements in mind when you're entering into lease agreements. Next slide, please. Some things to consider in COVID-19. So we're now, unfortunately, in the midst of a second COVID wave. As I'm sure all of you know, some parts of the province are in lockdown, like us here in Toronto, and many others are in the red zone. So what does COVID mean for you as tenant? If you are a tenant who's leasing space under a lease agreement, this means that you'll still need to comply with the terms of your lease, which may, in some circumstances, allow landlords to impose additional obligations on the use of the space in response to the pandemic. The terms in your lease may also inform your ability as tenant to make changes to the physical space that you have leased and the manner in which that space is accessed and used. So again, if there's ever any doubt, the first point of reference is always going back to your lease agreement. If you do need to make any alterations to the space that you're leasing, make sure you review and understand your rights and obligations under your lease. And of course, if you're unsure of what you can or cannot do, contact a lawyer to review your lease provisions for you. Also, if your clinic space is located in a multi-tenant building or complex, you may want to determine whether the landlord will be implementing any reconfigurations or changes to the space to ensure health and safety. So for example, are they going to be making any changes to the ventilation, the cleaning and use of any elevators, and the frequency of cleaning and use of any common areas and other communal spaces? Next slide, please. Last, but certainly not least, I'd like to touch on some financial supports that might be available to tenants from the government. So back in April, the Canadian government introduced the Canada Emergency Commercial Rent Assistance Program, also known as CECRA. And this program was set up to provide relief to eligible commercial tenants by reducing their gross rent by at least 75% from April to October. And under the CECRA program, the only way to access the relief was if the landlord opted into the program, which also required the landlord to contribute 25% of the rent. So in practice, what this meant was that the landlord, if the landlord didn't opt into the program, then the tenant didn't have access to the financial relief. And many landlords did not opt into the program because they didn't want to be out of pocket the 25%, so they took a chance. This program, the SECRE program, ended in October, and then in early November, just earlier this month, the federal government announced the new Canada Emergency Rent Subsidy Program. It's known as CERS, and introduced Bill C9 into the House of Commons to implement new targeted supports to help businesses. And actually late last week, just last Thursday, Bill C9, whose full name is, bear with me here, an act to amend the Income Tax Act, Canada Emergency Rent Subsidy and Canada Emergency Wage Subsidy. It's not a mouthful at all. Was proclaimed into force, so that means it is now law. Next slide, please. So what does CERS do? Unlike SECRA, its predecessor, qualified renters and tenants can now access rent support directly from the federal government and not through their landlords, which is, of course, good news for commercial tenants. Under CERS, rent subsidies will be available to businesses that suffered a revenue drop, and the subsidies are on a sliding scale up to a maximum of 65% of eligible expenses, and these eligible expenses include rent, property insurance, and property tax, up to a maximum of $75,000 for any one location and $300,000 overall for each claim period. The first claim period for which a commercial tenant can now submit an application under CERS is from September 27th to October 24th. And there are 2 other claim periods coming up. And at this time, the program parameters really only apply until December 19th of this year. And then they may be adapted further by the government in 2021 as needed. One catch of the program of CERS is that it requires tenants to actually pay the rent before retroactively applying for the subsidy. The CRA website does indicate, and I checked this earlier this morning, that applications that are submitted by November 30th will be processed on that date, with payments hopefully starting as soon as December 4th. So at least things seem to be moving fairly quickly given the circumstances. And in addition to this rent subsidy, there's also a new top-up revenue reduction percentage, which provides a top-up of 25% for organizations that have to temporarily or partially shut down for at least 1 week by a mandatory public health order. So while this doesn't apply to this sector at this time, it is something to keep in mind if further lockdown orders are issued and we're thrust into the same situation that we were in just a few months ago, where optometrists had to shut their clinic doors temporarily due to the pandemic. If you have any questions about CERS or whether you are eligible, I'd encourage you to contact the CRA's Business Inquiries line, and their phone number is up on that website. If you just Google CERS, then you can immediately access the website. And the CRA has also indicated that they will host a series of interactive Q&A sessions for eligible businesses, but they haven't released the dates yet. So if this is something that might be of interest to you, I would suggest that you keep an eye out on the CERS website. They're pretty good about updating it. Next slide, please. And so moving on to some provincial legislation in Ontario to help commercial tenants. On November 5th, our Ontario government introduced a Bill 229, the name of which is also a handful, but it is called the Protect, Support, and Recover from COVID-19 Act Budget Measures 2020. Our legislators are very creative with their names. So as of November 23rd, the bill has actually gone through second reading in the provincial legislature. If this bill is passed into law, Schedule 5 of the bill would make some amendments to the Commercial Tenancies Act, and it would establish a non-enforcement period for certain tenancies as it relates to landlord evictions and repossessions. And this period will begin on the day that Schedule 5 to the Act comes into force, and it will end on a date that has not been prescribed yet. What do these changes mean? What they mean is that the landlord cannot exercise a right of re-entry or distress, like seizing tenant property for rent arrears, during this non-enforcement period. And if a landlord does exercise a right of re-entry, or has exercised a right of re-entry, I should say, between October 31st and the start of the non-enforcement period, which will be set out in the legislation, the exact date will be set out, then the landlord must restore possession of the premises to the tenant, or if they can't do that, then they have to compensate the tenant for damages. Also, if a landlord does seize a tenant's property between October 31st and the start of the non-enforcement period as distress for rent arrears, then the landlord has to return any unsold property back to the tenant. So, in short, what this means is that if this Act and Schedule 5 are passed into law as it's currently written, it will extend the temporary moratorium on commercial evictions and have restrictions on distress rights for the landlord, which is, welcome news by businesses and small businesses in Ontario that are struggling to keep up. Just keep in mind that this Act, again, has not been passed into law yet. If it is passed, there could be still some changes to it. So this is just based on the information we have as of today's date. Next slide, please. So we've covered a lot of material today, and I'd like to leave you with some final thoughts as you navigate this leasing world. So as we discussed when we started off our session, leases are not a one-size-fits-all. The type of lease that you enter into will depend on the space that's being leased, the location, and of course, the landlord. Landlords often do like to present leases as standard documents that must be signed as is. But from a risk management perspective, there are key areas that can and should be negotiated for tenants, some of which we touched on today. When you're entering into a lease for clinical space, of course, keep in mind the college's requirements around access to premises. And given the uncertain times that we're all currently in, there have been various government programs and initiatives to help small businesses and tenants with rent subsidies. So I'd encourage you to review the subsidies, resources, and supports that might be available to your business during COVID. And if you need to, take advantage of those available programs. And of course, I'd be remiss if I didn't say that if you're unclear about the provisions of a lease that has been presented to you, or there is something going on and you need advice on the current provisions in your existing lease, you need support when you're entering into a lease, seek legal counsel to guide and assist you through the process. It can sometimes be overwhelming, but seek the right supports and you shall prevail. Next slide. So this brings us to the end of our session together today. I'd like to thank you for attending this evening. I'm happy to open the floor up to questions, and I'll hand it back over to Cheryl.
Thank you so much, Meg. So again, if you have a question, please type it into the question box. We do have a few questions, Meg.
Okay, great.
Does my professional liability insurance cover leases?
So your professional liability insurance would not typically cover leases. Professional liability insurance is just that. It's for any, clinical issues that might come up. The type of insurance that would be required under a lease is typically the commercial general liability insurance. And so if you're unsure about what your insurance cover or what kind of insurance you need to get, again, I'd encourage you to contact your insurance provider just to ensure that you have the right coverage in place.
Good, thank you. Another question, would I qualify for the CERS subsidy if I'm signing a new lease?
Okay, so that's actually a really good question, and I didn't touch on that in the presentation, but I guess I should have. So another catch of CERS is that the subsidy under CERS is only currently available for written agreements that were in place before October 9th of this year, or a renewal on substantially similar terms of such an agreement. So what this means is that it doesn't actually at this time apply to any new leases or leases that were not in place before October 9th. This could change. So I'd just encourage you to keep an eye out on the CERS website that's updated by the CRA fairly regularly to see if there are any changes to that.
Great, thank you. Another question, if a 5-year lease with options to renew is up for renewal in 2021, is the landlord allowed to increase the rent? Are there any limitations?
There's no limitations at law. It's just what you would negotiate as part of a lease. If the lease is up for renewal and there are renewal provisions in the existing lease, there might be something in those renewal provisions around what would be the rent or how much the landlord could increase it should the lease be renewed. So that's something you'd have to check for in your existing lease.
Okay, thank you. If leasing a full building under a triple net lease, who is responsible for a new roof, repaving the driveway, HVAC, etc.?
So I missed the first part of the question. If leasing a space under a triple
net lease.
Triple net lease. It really depends. So the net concept is the base rent and then the additional rent. Replacement of structural elements like the roof or the sidewalks typically would be landlord responsibility, but if you're leasing the whole building, they might be the tenant's responsibility. So again, it just depends on whatever is negotiated at the time of the lease that it's when it's being entered into.
Okay, so I'd have to check the lease.
That's right.
Yeah. Another question, what is a typical percentage increase in rent? 1% yearly, 2% yearly?
That's a good question. It really could be anything. A lot of it sometimes is tied to the standard increases in the cost of living, so like 1 or 2%. But again, from like a legal perspective, there's no right or wrong. And typically, if you have an escalation built into the contract, it's just whatever's been negotiated at that time. And again, given the circumstances and the times that we're in and the struggles of small businesses and the drops in revenue, it does seem like landlords do want to try to hang on. At least some landlords want to try and hang on to the rent-paying tenants. And so it's always a matter of negotiation and goodwill between the parties.
Great, thank you. We have another question. Is there an equivalent to something like title insurance, which is used for property purchases? Is there an equivalent type of insurance to protect lease terms? That might be more an insurance question.
I think so. I'm not aware of any specifically for leases, but whoever your insurance provider is, whether it's Hub or another organization, I'd suggest you contact them.
Right. Okay, that's all the questions we have at this time. So I'd like to thank you so much, Meg. It's a great, insightful presentation with really up-to-date information. So thank you for doing that due diligence. And I'd like to thank Miller Thompson for partnering with OAO for tonight's